Thank you. Hello, everyone. I'd like, first of all, to thank the organizers of this conference for inviting me here. As you may be familiar with, the European Union is developing a European integrated border regime as the linchpin of the improved and more efficient migration management in the EU. And such integrated approach to border management is conducted within a multi-level governance system of binding rules and different actors, which of course raises concerns as to the exact extent and concrete content of shared competencies and corresponding obligations and responsibilities held by the EU member states authorities. The EU member states have retain their own competencies and responsibilities in the area of border safeguarding and entry into their territories, and of course this is expression of their sovereignty. So in this presentation we are going to concentrate on the obligations and responsibilities of the EU member states authorities in the area of border management within the framework of first, the EU's internal competence, and second, the external action by the EU. As for the EU internal competence, the member states have first and foremost an obligation to take the necessary implementing measures when the EU adopts common rules by exercising its competence. Such an implementation of EU common rules may take the form of legislative measures in the case of transposition of directives, or administrative measures in the case of applying regulations. Moreover, the national courts of member states are responsible for appropriate judicial implementation of common rules, which means that they must always ensure the effective application of EU law as required by the principle of primacy, also when, for example, national law is contrary to EU law. Since in the case of border control, management of new arrivals, illegal border crossings into the EU, and also regular migration, the EU's action does not cover the whole area, but is currently limited to the higher or lower degree of harmonization of national provisions. The member states are, within the framework of their institutional autonomy, required to either take the necessary administrative measures in directly applying a number of regulations related to EU border management, or they need to adopt measures to transpose the relevant EU directives, notably those pertaining to the legal and illegal migration and to the return of third country nationals. If a member state does not transpose a directive in question, or if it transposes it incorrectly, it fails to fulfill its obligations, and the European Commission may, in accordance with the provisions of the Treaty on the Functioning of the EU, initiate infringement proceedings and bring proceedings against that member state before the Court of Justice of the EU. Where a member state fails to transpose a directive in a prescribed period or transposes it incorrectly, individuals may still rely on sufficiently clear, precise, and unconditional provisions of such a directive against that member state in proceedings before the national courts. Moreover, individuals who have suffered loss or injury because of the member state's failure to adequately implement or transpose common rules may bring an action for damages against that member state before the national court under the conditions established by the Court of Justice of the EU in Frankfurt. When the member state's jurisdiction is not affected by the exercise of the EU's competence in connection with the management of borders, they may adopt national measures which go further than the EU legislative framework. However, national measures must always comply with the minimum rules of the EU legal framework within which they are adopted, as well as with the EU's fundamental rights provisions, and also with some other EU rules. In the case of minimum harmonization, a directive sets minimum standards, often in recognition of the fact that the legal systems in some EU member states have already set higher standards in regulating certain area or certain subject matter. In such a case, member states have the right to set their standards higher than those set in the directive. For example, the Return Directive allows the member states to adopt or maintain provisions that are more favorable to illegally staying third country nationals. However, this directive does not allow the member states to apply stricter rules in the area covered by it, which was also confirmed by the Court of Justice of the European Union. Although the member states have a certain discretion in applying acts on border management issues adopted for the purpose of harmonizing their laws or regulations, they must respect the minimum rules and not act in a manner that could undermine the effectiveness of common rules. In implementing EU rules concerning border management, the competent member states' authorities are required to apply their margin of intervention of discretion in a manner that ensures full respect for fundamental rights. This requirement is enshrined in Article 67 of the Treaty on the Functioning of the EU, which provides that the Union shall constitute an area of freedom, security, and justice with respect for fundamental rights. Moreover, Article 51 of the Charter of Fundamental Rights of the EU provides that beside the EU institutions, EU member states are also bound to comply with the Charter when they implement EU law. In a range of their border management activities, including border surveillance, apprehensions at land, sea, and air borders, and the operation of referral mechanisms, notably in the event of mass arrivals, EU member states have an obligation to implement EU law in full compliance with the rights and requirements of the EU Charter, which has the same legal value as the EU treaties. In areas not covered by EU law, member states must still comply with the rights protected by the European Convention on Human Rights and other international human rights and refugee law instruments to which they are parties. EU law instruments regulating border management and related migration issues and establishing the set of rules that regulate the functioning of the Schengen area, notably the Schengen Border Code, the regulation on Schengen evaluation and monitoring mechanism, and the regulations on EU funding for border management. These instruments contain several clauses and safeguards intended to protect fundamental rights, especially those that are more often at stake in border management and migration control. The member states must ensure that the fundamental rights are respected and protected in law as well as in practice. This means, first of all, that their national legal systems must fully incorporate the requirements and safeguards flowing from EU law, the European Convention on Human Rights, as well as international human rights and refugee law. Likewise, the member states' national integrated border management strategies must adequately reflect fundamental rights. According to the most recent report prepared by the EU Fundamental Rights Agency on the fundamental rights situation in the member states, immigration, borders, and asylum legislation, for example, in Latvia, Lithuania, Poland, and Spain, is inadequate, as it allows the border authorities in certain circumstances to redirect third country nationals who entered these member states' territory in an unauthorized manner to the neighboring country they came from without assessing whether such a removal actually violates the principle of non-refoulement. Also, Finnish and Estonian migration and asylum laws can be considered quite problematic in this regard. More importantly, the fundamental rights guarantees and national strategies need to be implemented and enforced by the border management authorities and guards in member states in their daily work. when they carry out, of course, border checks and controls at the EU's external borders. Effective protection of fundamental rights also requires systematic reporting of any violations, particularly those that may constitute serious crimes. Then it requires prompt and effective investigation of all allegations and effective and dissuasive sanctions when human rights and international protection violations occur in carrying out border management activities. Independent and regular monitoring at external borders can also help identify fundamental rights risks before violations may even take place. The Member States' obligation to save lives of migrants to reach the EU borders by the sea requires them to deploy the necessary search and rescue capacities. The European Court of Human Rights, for example, recently held in Sofia and others against Greece that the Greek national authorities had not done all that could reasonably be expected of them to prevent the loss of lives. This is actually the first time that the European Court of Human Rights applied this positive obligation of a state flowing from Article 2 of the European Convention on Human Rights to a maritime search and rescue operation concerning asylum seekers. And in its ruling, the European Court of Human Rights moreover noted shortcomings in national investigation proceedings and reiterated relevant safeguards for a thorough and effective investigation of such incidents. Also, in a recent criminal case in Italy that resulted in a conviction in 2022, the Rome tribunal found 2 Italian officers guilty of manslaughter because they failed to act in response to a shipwreck in 2013, in which, as you might remember, over 200 people drowned. However, as the crime has since been declared to be time-barred, the 2 officers were not punished in the end. Although the member states have an undeniable sovereign right to control the entry of non-nationals into their territory while exercising border control, they still have a duty to protect the fundamental rights of all people under their jurisdiction, irrespective of their nationality or legal status. Under EU law, the member states have an obligation to establish dedicated mechanisms for lodging administrative and judicial complaints through which migrants, asylum applicants, and refugees can submit allegations of human rights violations at the member states' borders. Where arguable complaints of violations of fundamental rights are made, the member states have a duty to carry out an effective investigation into those allegations. And such an investigation must be prompt, it must be expeditious and capable of leading to the identification and also to punishment of those responsible for fundamental rights violations at borders. It also often happens that migrants are turned back at EU internal borders, that is, borders between the member states. The member states in Southern Europe and along the Balkan route have increasingly used such intra-EU bilateral readmission agreements concluded between 2 member states to pass back to a neighboring member state those migrants who they have apprehended in connection with their irregular crossing of an EU internal border. Member states are allowed to do so under Article 6 of the Return Directive for those migrants in an irregular situation and provided that a readmission agreement existed before 2009. However, for asylum applicants, the transfer procedures set out in Dublin III regulation must be applied. And in this context, some rulings of the courts in France, Italy, and Slovenia reaffirmed the duty to respect the right to asylum and the principle of non-refoulement also in such intra-EU situations. then other EU rules, law rules, still have an important impact on border management issues, notably in the area of free movement law, but also data protection law and association agreements. In exercising the competencies reserved for them, the member states must not undermine these rules and principles of EU law. In accordance with the principle of sincere cooperation, the member states' margin for intervention in border management, migration and asylum matters must not affect the application of more specific provisions concerning the situation of third country nationals, such as those relating to EU citizenship and freedom of movement. As regards the EU's external competence, the member states' competent authorities have two types of obligations. First, they have an obligation to implement international agreements relating to border management and concluded by the EU. And second, they have an obligation to facilitate the EU's exercise of its external competence. International agreements that the EU concludes with one or more third countries or international organizations are binding not only upon the EU institutions, but also upon its member states. Such agreements constitute common rules which the member states must implement. In the case of their non-implementation, a member state fails to fulfill its obligation, and this is then subject to sanction by the Court of Justice of the EU. The member states' competence in connection with border management is affected by the conclusion of so-called status agreements and readmission agreements by the EU. In accordance with the principle of sincere cooperation, the member states are required to implement these agreements which supersede any prior member states' agreements. Moreover, the member states' competence in connection with border management must not hinder the implementation of international agreements concluded by the EU which relate to the free movement of third country nationals, such as association agreements. Third countries may be associated with the EU through the conclusion of association agreements, and almost all EU accession agreements are concluded in the form of mixed agreements, which implies that beside the EU, its member states are also involved as parties in their own right. This means that EU association agreements are binding on the member states as a whole, regardless of the division of competencies between the EU and its member states. And hence, the reservation of member states' competence in connection with entry, border crossing, and immigration for employment purposes, for example, cannot preclude the implementation of EU association agreements, which include provisions on the rights for nationals of the partner country. Then the exercise of the member states' external competence must not undermine the EU internal common rules. This entails that the requirement of compliance in the exercise of the member states' internal competence applies equally to the member states' international activities, such as the conclusion of readmission agreements and agreements with third countries concerning measures on the crossing of the EU external borders. In the context of local border traffic regime, the member states may conclude bilateral agreements with their neighboring non-EU countries, and these agreements are intended to ease the crossing of the EU external borders for the border residents who frequently need to cross the external borders of the EU. When the EU has not exercised its competence in connection with the partner country in question, then the member states may also conclude readmission agreements. And last but not least, in exercising their shared competence in matters of border management at international level, that is within multilateral fora, such as the United Nations, the Council of Europe, OECD, and so on, the member states must ensure, in accordance with the principle of sincere cooperation, the unity of the EU's international representation by presenting a common position of the EU. And I'll stop there. Thank you for listening.